Good afternoon. My name is Attorney Allison Tilton.
And I'm Attorney Michael Bender, and we are the Gray Legal Group. Welcome to today's edition of Ask a Lawyer on Facebook Live. The contents of this video is for general information purposes only. Nothing should be taken as legal advice for any individual case or situation. This information is not intended to create any receipt or viewing, does not constitute an attorney-client relationship.
All right, so we're just going to go ahead and something very funny is happening. We're going to go ahead and jump right into the questions that we presented this week. Michael's going to be giving you guys an answer first. The first question we have has to do with grandparent rights. Do grandparents have rights to custody in California? My grandson is 4 years old, and I have watched him for my daughter and her husband since he was born. They are now divorcing, and he got primary custody due to my daughter being arrested. He won't allow me to see my grandson.
Well, this question really has two separate answers. With regards to grandparents' rights, yes, there are grandparents' rights, but not necessarily to custody. In a divorce case, paternity case, or what have you, there are certain situations where you can establish visitation for grandparents. There's certain thresholds that can be met. However, starting right off the bat, if both parents believe that it's not in the best interest of the child to have contact or have visitation with the grandparent, the court is going to presume that that is the correct situation and not allow any grandparent visitation. However, if one parent in this situation is excluding the child from the grandparent, if you can establish that there's a long-term relationship there, you can actually ask the court to establish visitation for you. When I say long-term, typically we're basically about a year's worth of contact. Here the situation is such that I've been watching the grandchild for since the grandson was born, so 4 years is going to be definitely long-term. So the court would have the ability in this situation to go ahead and look at granting some type of visitation. Custody is a different question, which is actually what the question was for. If both parents, if you feel that both parents are not suitable, you can actually file for a guardianship. That would not be in family court, it's through the probate court, and there's various thresholds. We can get into that another day. I'll go on to question 2 here. We get talking about alienation or interference with custody. Can I sue my ex's new wife for alienation or interference of custody? My ex and I share custody of our children. My 8-year-old son has started acting up when he's with me, saying he doesn't want to stay. He also tells me my ex's new wife says things about me like I'm a bad mom or I do drugs, which I do not. Sometimes when I try to pick them up, my ex's new wife won't let them come or has taken the kids somewhere so I can't get them. My ex has threatened to take custody from me because the kids tell them they don't want to be with me. That's a lot.
That's a very, very long question. So the basis of the question are asking whether or not you can sue your ex's new wife for alienation or interference of custody. Quite frankly, no, you can't. There is no cause of action that allows you to, no cause of action in family court that allows you to sue your ex's new spouse regarding their interference with custody. The issue is actually in your divorce case with your ex-spouse as to whether or not the custody and visitation orders are appropriate. Based on the facts that are presented, it may very well be appropriate for mom to file a request for order and ask the court to limit the kid's ability to spend time with the new wife. There may be the necessity of what's called, I think we've talked about this previously, a child custody evaluation to deal with these issues. But with regards to him threatening to take the custody because the kids don't want to be with you, you mentioned that at least one of your children are 8 years old. That's a little young for the child to really have a say as to what custody visitation should be. But it is possible that the court would want to consider what's happening, especially in the child custody evaluation context. But in terms of being able to sue that new stepmom, it's not going to happen. I don't see a way for it to happen.
To answer the direct call of the question, no.
Yeah.
Okay, well, thanks for joining us today on Ask a Lawyer. Join us each week as we discuss family law issues important to our community. If you have a legal question or topic you'd like us to discuss, go to thegraylegalgroup.com and click on Ask a Lawyer.